All of that, again, it's like tying your shoes. So
yeah,
something feels wrong.
I agree.
All
and
right.
when it smells bad, let's ask our guest for this hour, civil rights and trial attorney Adanté Pointer. Thank you. You know, sometimes when it smells bad, it is bad. Is that the case here? What's your opinion?
Things are rotten in Denmark. It certainly is bad. It's certainly, you know, as a setback for the prosecution. And when you're dealing with police officers, especially one that's as senior as the one that we're talking about here, who blurted out things against court orders in court, you're talking about a person who has testified in court a number of times, knows how to play within the rules, but also knows how to flaunt those rules if they should feel like they want to. And so I think what you're seeing from Gibson civil attorney Carlos Moore, as well as the district attorney prosecutors in this case, and the world, frankly, who are watching this case, is why would a police officer do such a thing like that on the stand? You almost know that that's a poison pill as it relates to the prosecution of this case by withholding such a crucial piece of evidence. And those are questions that will have to be answered probably more administratively within the department, because I would think that there would be an internal affairs investigation as to how such crucial pieces of evidence did not make it into the hands of the defendants and the prosecutors, and was that intentional or just simply neglect? Those are the questions that everyone wants to know.
And Adanté, you just hit the nail on the head. I thought there's got to be an internal affairs investigation. There can't not be. But Michael, we don't know that there's going to be yet. They haven't said that.
We don't, but I think, Adanté, and you're someone who's familiar with this area, it sounds like the defense, the victim's attorney is doing the right thing. He's in contact with the Department of Justice. He's, you know, letting them know what's going on. They apparently have been monitoring. They had not decided whether they're going to come forth with charges or hate crime charges. In this instance, if he can show, or at least something shows that something is amiss here, and again, this is the kind of thing where if it walks like a duck, talks like a duck, it's a duck, do you think the Department of Justice might get involved?
It's certainly a possibility. The Department of Justice clearly is monitoring the situation, but they have a lot of situations that they monitor every year, and only a small percentage of those do they actually take an active stance and get involved and prosecute someone. I just think, following what the judge says, this is the first time he's ever seen anything like this in umpteenth years of him being on the bench. And even for myself, who have seen any manner of interference in the pursuit of justice of victims, it's stunning to see that the police did this on such a high-profile case. It just lets you know that there's something amiss, and if I'm the Department of Justice, I'm going to bring the resources to bear in order to get to the bottom of it. And certainly, even if I'm the prosecutor in this case, now I have questions as to what other poison pills are waiting for me on the second go-round when I try this case. And I'm going to have a sit-down with the department, primarily the chief, and shake the bush to make sure that I have every item of evidence, and then I'm not blindsided like this, left with egg on my face.
Yeah, and again, if this was not innocent mistake, one has to wonder if there's layers to this thing, that this is not the only situation where this has come up, where something like this has come up, where this department has been responsible for this. It may call for a larger investigation. Internal investigation might not be enough.
And that's my gut. My gut is they better start peeling back the layers to make sure that's not the case, because this one feels suspicious to me. But I have to tell you how much I appreciate that the victim's attorney in this case said, hey, I agree with the judge's decision, because I do too. I think yesterday when it came up, I thought, uh-oh, I think these are grounds for a mistrial because they don't have all that information. They were going to talk through that. But then when I think what tipped it over the edge, and I told you this, Michael, but Adanté, I think what tipped it over the edge is when he starts talking about the other guns, about shell casings that were found, things that weren't allowed to come into evidence. And I think once you get that in front of the jury, in and of itself may be a curative instruction. But when you have that in conjunction with, we didn't provide all this, I think the judge's hands were tied.
Agreed. You know, at some point in time, the scales are tipped so far in a prejudicial manner, unduly prejudicial manner, that the judge has no choice but to declare a mistrial. And when you start talking about guns and those type of character evidence, if you will, that could paint a person to be violent, and therefore a jury could be led to believe that a person committed a crime, not based upon the evidence that shows that they were directly connected to the allegations or the charges, but because they have a pattern or a history or characteristics that are not favorable in a case like this, then that puts a conviction at risk anyway. And so I think the judge looking at this on balance is saying, look, let's nip this in the bud early and just have a restart, a redo, and do it the correct way versus go all the way to the finish line only to then snatch a conviction or an acquittal out the jaws of the jury, because on appeal, a judge or a panel could say, look, this was too prejudicial. This was too beyond the pale of anything that should be presented to a jury, and so we have to do it again anyway. So
yeah,
I think the judge took a more proactive approach.
Yeah.
Adanté, let's be clear. When we say, okay, let's do a redo, it's not that simple, right? At the end of the day, you had the time and money and effort already spent on getting to the case to this point is staggering. The sacrifices made by the jury to take time out of their day, of their work. A lot of people can't necessarily miss days of work, and they were missing. Ostensibly, they're not really being paid. So there was a lot of cost here when you look at both money as well as time, as well as people's, just lives. But let me ask you this. There should be no problem just bringing this one again to trial. This one's not going away because of this.
It should not go away. If the prosecution, the district attorney's office was really committed to the case, then the fact that there's more evidence that come out, yes, they'll review it, and that has to be factored into, their presentation to a jury. But at the end of the day, they should still be moving forward with this case. The question mark for me is, they say that this is an interview by the FedEx worker. Well, the question is, are there any inconsistencies between what he originally said versus what may have been said in these subsequent interviews? And does that allow an opening for the defense to raise reasonable doubt? Those are the questions that we're all going to have as we tune up to see what happens in stage 2 or round 2 of this prosecution.
And there's been a lot of talk about the reaction that we saw from the mother of the FedEx driver. She was angry, she was frustrated, she stormed out of the courtroom after she said something in the courtroom. But I have to piggyback on what you said, Michael. This is not because there was a case, it was investigated, there were charges, we're going to trial, there's a mistrial. This is because, to your point, it took 10 months to even get here in the first place. And my understanding from everything I've read is the only reason we really got to this place is because that family pushed and pushed and pushed. So Adanté, should it have to be that important for a family to push and push and push to even see charges in cases?
A victim should not feel re-victimized by the very system that's put in place to protect them. And so, what you see here is, it sounds like the prosecution was dragging their feet, or perhaps the police department were dragging their feet in getting the evidence to the district attorney's office so they can make the charge. That is something that it smacks of what happened in the Ahmaud Arbery trial, the young man who was killed while jogging in the state of Georgia, where prosecutors are not being zealous prosecutors in bringing these type of cases to trial. And it harkens to me when I looked at the young man's mom storm out of court upset at the mistrial, what Dr. Martin Luther King said, which is, justice delayed is justice denied. And I'm sure that's how the mother and even the young man is feeling right now. Why is it taking so long to get my day in court?
Fair.
Yeah, and I'm sorry, I forgot when I was talking about the cost of this mistrial to the family of the victim. After all they've been through, thinking that they're finally going to get some justice, their day in court, and they don't. So you can understand the mother's anger there.
Absolutely.
Well. Yes. All right, Adanté, stand by. We do have to take a break. Folks, coming up, we're going to take you back to the sleepover kidnapping murder trial to hear more expert testimony.